Welcome everybody to the CrySP speaker series on privacy. Once again in the new COVID era online format. Hopefully at one point we'll be able to do this in person again, but probably unfortunately not very soon. So it's our great pleasure today to have Riana Pfefferkorn. She is the Associate Director of Surveillance and Cybersecurity at the Stanford Center for Internet and Society. She's been doing that for about 5 years, and I would characterize her work as examining the US government shenanigans with regards to cryptography and policy. And her work is widely known and widely esteemed online and all over the US and beyond. And it's our great pleasure to have her here. So let's welcome Riana.
Thank you, Ian. Thanks for having me here today. It's really a pleasure to be part of this speaker series. I was excited to see how many excellent guests you've had in the past. And so I'm very pleased to be the latest one of them. Can everybody see my screen okay? Yes. Okay. Gonna assume so. All right, let's get started. I'm probably just gonna refer to, every talk is just gonna be titled shenanigans from now on, since that's a pretty accurate summary of the one-word answer to the rhetorical title of today's talk, What's New in the US Crypto Wars. I've tried to include some of the CBC mandated minimum percentage of Canadian content sprinkled throughout this talk, but it will largely be focused on the United States. And, of course, what happens here within our borders has ramifications for policy and technology beyond US borders, including in Canada. So, I think that will be relevant to how folks in Canada should be aware of what is going on because of the impact that it may have on you. As a content warning, I'm going to talk a little bit about some pending legislation in the United States that is addressed to the topic of child sex abuse online. So if you have any sensitivity around that, hopefully you can just step away for a moment or do what you need to do. As an overview, right now in the United States, strong encryption is legal. If US law were not the way it is, if it did not give US tech companies the freedom around encryption that it does, we wouldn't be having this debate over encryption because we wouldn't have the iPhone and iMessage and WhatsApp and Signal, et cetera, in the forms that we have them today. Right now, I'm using strong encryption to mean encryption which has not been intentionally weakened at the behest of a government is fully legal in the United States for the time being. It wasn't always this way. Some of you may have a little familiarity with the background of the more contentious era from the 1970s, when my Stanford colleagues, two gentlemen named Diffie and Hellman, came up with public key cryptography up through the late 1990s, during which time the United States government classified crypto as a munition akin to a bomb. And so it was subject to certain export controls. If you've been around for long enough, you'll probably remember the export grade versions of Netscape's browser versus the domestic version, which had different strengths of encryption for them. Encryption technology export is still regulated, but now we've classed it under the Department of Commerce, and the regulations are much more relaxed. And of course, the idea of export grade cryptography was that Americans should have good security, but that the National Security Agency should be able to pwn everybody else. So we had stuff in the 90s like 40-bit session keys, which is now you can break that with a toy decoder ring out of a Cracker Jack box. And this proved to be a really stupid long-term policy decision because, of course, what was only breakable by somebody on the level of the NSA at one point in the past is now trivial to do today, as just said. And so hence, as I'm sure all of you are familiar with, the freak logjam and drown attacks that researchers showed a few years ago all are blamable in some degree on export grade crypto from the 90s and on those old export controls. So that turned out to be a really nearsighted policy approach. And yet today, as I'll discuss, we have some renewed efforts to try and similarly shackle encryption technology in a way that we will not know the circumstances of necessarily down the road until we trip right over them. The reason why the policy approach has turned out to be nearsighted is in part because of a legislative landscape that kind of preceded the popular importance and deployment of encryption. Which of course, in a chicken and egg style would not have been possible had we not put those relaxed policies into place at the end of the 90s. The policy and law decisions that were made in the late 90s and the mid 90s have renewed relevance today. The 1990s gave us several US laws that are relevant to the encryption debate today. First among them, the Communications Assistance for Law Enforcement Act of 1994, or CALEA for short. This was passed in 1994 because even back then, a quarter century ago, law enforcement was concerned that they were going dark due to the advent of digital telephony and the internet. So what CALEA does is to mandate that there be access to phone networks, telecommunications carriers, for law enforcement purposes. The statute as originally written covers telecommunications carriers. It also has been expanded over time to cover new communication services that our Federal Communications Commission, which is our ICT regulator, deems substantial replacements for traditional local phone services. And so now that has been deemed to include two-way interconnected VoIP as well as broadband internet. There were some important compromises that were struck in CALEA as a result of a long and drawn out fight among the various stakeholders in the room at the time, which included not just law enforcement and congressional policymakers, but also security experts, privacy and civil liberties advocates, and others who were trying to think beyond just this narrow box of law enforcement access. And one of those compromises was that while the goal of wiretappability for the network for covered entities such as telecommunications carriers is dictated by the law, the how cannot be dictated by the government. So entities are free to design their systems to comply with this wiretappability goal, however they may choose to do so. In addition, there are a couple of important carve-outs to CALEA that have grown in importance over time from when they were passed in 1994. One of them is what's called the information services carve-out. CALEA's covered entities do not include information services, which is basically the internet, which is how I say it after hearing Ian say it that way at a talk at I think CodeCon in 2006 or something like that. And so ever since, whenever I refer to the whole of the internet, I say it the internet, although I don't have the resonating basso profundo that he does. And so CALEA does not cover website, social media, chat, email, etc. All of them can design their encryption however they want. They do not have to make their networks and their services accessible for law enforcement surveillance. And this was deemed important at the time because in 1994, we were still trying to get this whole technology and internet sector of our economy off the ground. And so that compromise was deemed to be important because after all, who in some other country is going to want to buy American software if it's known to be backdoored for the US government? Similarly, even covered entities, meaning telco carriers primarily, have a carve out that allows them under CALEA to encrypt communications and throw away the key. That again was a compromise that was reached because security experts and civil liberties groups had pushed for those limitations. So they only have to decrypt a communication if they were both the one to have done so. So if there's some third party over the top solution, obviously it doesn't make sense to require the telco to decrypt it. And if the entity still possesses the information necessary to decrypt it, i.e. they have the decryption keys. So the bottom line is that the CALEA statute does not require Apple or Facebook or Signal or whoever to build in exceptional access, which is what law enforcement likes to call a backdoor mechanism, as demanded by our Attorney General and our Federal Bureau of Investigation. And because of that inability to dictate a solution, a compliant solution, the government cannot restrain the innovation of secure technologies under CALEA. If they did back in 1994, then as said, we would not be having this conversation today. Instead, CALEA left US companies and even telecommunications carriers free to design encryption that even they couldn't decrypt and free to innovate in terms of how they want to improve their security over time. And so now if you fast forward to 2020, encryption is now in ubiquitous use by consumers because it's built in by default to popular devices and apps. And this is exactly what United States law allows, even though you have various iterations of our Attorney General, as well as senators, all of whom should know what CALEA says. Some of them are ancient enough that they were even there when this was passed 25 years ago, screaming about how companies like Apple and Facebook are acting above the law and creating lawless spaces through strong encryption. That's not true. Those companies are doing exactly what law allows them to do and has allowed them to do for 25 years. It's simply that this freedom to encrypt, those carve-outs and limitations that were built into CALEA were not that big of a deal until the state of the technology and the usability and the broad deployment caught up with this relatively far-sighted compromise that was struck in the mid-1990s. And so now today, arguably, that going dark fear is perhaps has more force for law enforcement than maybe it did back in the 1990s. They got their access to phone calls. They did not get their access to encrypted communications as a result of that compromise. And so now the fact that this is deployed ubiquitously rather than being a user hostile piece of software that you have to configure and get just right because it's going to, fail in a non-privacy preserving way, et cetera, you're all familiar with how terrible previous versions of encryption software were to use for the average user. Now that that has just been built in by default, you don't even have to think about it and nobody has to fiddle with things endlessly, that raises issues for law enforcement because it's not just the small number of motivated, sophisticated criminals who are using it anymore. It's every average Joe out there. So that's CALEA. But CALEA, as said, is only about telco carriers. It does not impose mandates on actual mobile devices. So what's the law around device encryption? At present, there is no express law that compels a company to decrypt data that it doesn't hold, which is stored on an endpoint, some end user's device. It used to be up until 2015 that our Department of Justice tried to use search warrants in conjunction with orders under a 1789 statute called the All Writs Act, or AWA. And I've put up there in the slide, it's a very short statute. This is the plurality of it. And it says that federal courts may issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law. Not exactly a super clear device decryption mandate directed to Apple or Google. And yet, up until late 2015, courts had been signing these orders. A search warrant would issue, allowing the search of a phone that the police had in custody, and then this AWA order would be issued to effectuate the judge's jurisdiction that had been obtained by the issuance of the search warrant. And courts had been issuing these orders without any analysis, and at least 70 of them were issued in secret in the United States. And Google and Apple, the companies responsible for the mobile operating systems and the ones to whom the devices would be handed over to try and unlock them, hadn't been challenging these orders up until late 2015. In fact, the orders that Apple received, the language in those orders was written by Apple. In their public-facing guidelines for law enforcement, they actually had just dumped in the language and said, here's the language that you need to put into a proposed order that you need to go and get a judge to sign off on if you want us to honor it. Which is understandable in as much as it allowed Apple to sort of dictate the terms on which it would be willing to unlock and extract data from locked devices for law enforcement in a way that clearly defined what the metes and bounds of their obligations were, so that the police could not then go back and come back and demand something else that was not within the wording of some order that Apple had not written. So it gave them some measure of control, but it was not necessarily consonant with the image that Apple has tried to project in recent years of being, the one that stands up for user privacy and trying to differentiate themselves on privacy, given that their business model is less dependent upon user tracking and advertising than other players in the big tech space are. But anyway, so in addition to drafting these orders, there have been all of these things that have been issued in secret. And every time the Department of Justice attorneys would go up before one judge, they would just say, hey, this has been approved in other cases by other judges, so you should approve this too. And when they submitted their applications asking for these orders, these unlocking orders, there would be like one paragraph's worth of legal analysis with like one citation to one court case. Extremely thin reasoning once it actually comes to light. But of course, because of the context, what we call an ex parte proceeding to get a search warrant issued, to get an all writs act issued for law enforcement, the person who's ultimately going to be on the business end of that order is not there, right? It's when a warrant is issued or some order to effectuate like this, of course, that's happening in a secret proceeding so that you don't tip the person off and they go and throw their phone into a lake or they delete their emails or whatever it may be. And of course, the interests of Google or Apple don't necessarily align 100% with the interests of their users. And because they were getting such a high volume of these kinds of unlock orders that had created weeks or even months-long waits, of course, they don't necessarily have either the resources or the will to stand up every single time. And try and challenge this. Maybe they were just biding their time. Maybe they were just able to sort of go along to get along for some number of years. But the first time that we actually saw a thoroughly reasoned legal opinion about the duties of these entities was not until early 2016 from a federal judge in Brooklyn. This is the lesser known Apple versus FBI case. And in that, the judge in Brooklyn said, no, the All Writs Act cannot compel Apple to decrypt a locked phone. CALEA is a comprehensive scheme. It did not just forget about Apple. The information services carve out was intentional. It placed intentionally, Congress did not choose to put any duty on Apple in CALEA to require decryptability and accessibility for law enforcement to encrypted data. And CALEA trumps this extremely vague, extremely short law that is so old that it precedes even our Fourth Amendment, which protects privacy in the US and governs searches and seizures. And the government appealed, but then they dropped the case later on when the defendant just magically remembered his passcode. Go figure. And so that opinion came out less than 2 weeks after the order, the original order in the better known Apple versus FBI case on the other side of the country in Southern California, in San Bernardino. Originally, in mid-February of 2016, the court there in Southern California had ordered Apple to design a custom version of iOS that rolled back 3 security protections, none of which required breaking encryption at all, but which were more about enabling the government to be able to use a piece of software to brute force the passcode without being foiled by the enforced waiting period in between missed password guesses or being limited to 10 or avoiding the phone potentially bricking itself after too many wrong passcode guesses. So none of that really touched the encryption. But it would obviously have been pretty momentous if these orders could just be issued to Apple any old time to install a piece of custom software on the shooter's phone for this mass shooting that had occurred in Southern California. And you'll remember that even if CALEA had covered entities such as Apple, with this hat-on of information services, CALEA does not allow the US government to dictate even to CALEA-covered entities, such as telco carriers, that they adopt any specific design for complying with the law. So even if Apple had been covered by CALEA in this context, which it's not, requiring them by court order to create and implement a workaround for the iPhone security features was precisely what CALEA prohibited. So 2 weeks later, when this judge in Brooklyn issues his opinion at the end of February, he was signaling very clearly in the direction of the court in Southern California on how it should rule, because this judge had issued this order that was drafted by prosecutors requiring the rollback of these security features and the creation of this custom version of iOS without any analysis at all, just signed off on the draft order that had been prepared by prosecutors. And then you have this like 50-page long opinion from the judge in New York that's just kind of like, maybe think again. And meanwhile, various friends of the court and various outside entities, including me on behalf of a brief that I co-authored for my Stanford colleague, Dan Benet, amongst some other iPhone security and cryptography experts, to explain to the court, like, this is a trash fire and you need to not do this and think again. So there were a couple of dozen amicus briefs that had been filed, from the court briefs, amicus curiae briefs, in this case in Southern California. But we didn't ultimately get a decision on the merits to actually see, once the judge was forced to wake up and look at the order she had signed and consider all of the arguments of the various amici. We didn't see a decision on the merits because the case fizzled out literally on the eve of what was supposed to be the court hearing about this, after the FBI revealed that it had bought an exploit from an unknown third party, possibly Celebrite, for around 900,000 US taxpayer dollars. Which is ridiculous, particularly given that they don't actually know how it works. They only bought the capability, and they don't actually understand how it works at all, as we subsequently found out through press attempts to try and unseal or get more information about that through Freedom of Information requests. So if you fast forward to today, that means that the resolution of that case means that we don't really have decision on whether this extremely short and vague law, the All Writs Act, can compel the creation of software. We have a judge in Brooklyn saying that it cannot. We have the San Bernardino judge who never issued a decision on the merits at all. And if you move forward a few years, in the intervening time, US law enforcement and the debate around encryption in the United States was mostly about devices, not about chat. And then suddenly in early 2019, the conversation shifted, largely because I think of Facebook's announcement of their plans to upgrade the encryption across all of their messaging services to be end-to-end encrypted by default, the way that they already do for WhatsApp, implementing the Signal protocol. And so the debate in the United States swung around to focus more on messaging services, with the exception of, because we're addicted to guns in the United States, another shooting, although that was by another non-US national, in Pensacola, Florida, on a naval base there, which involved, again, a locked phone by, again, a mass shooter, which, again, investigators were initially unable to get into, which had the potential to turn into a rematch of the San Bernardino Apple versus FBI case. But again, embarrassingly for them, the Department of Justice succeeded in breaking into the shooters' phones themselves, evidently using their own homeworld solution, because the FBI has, which is part of the DOJ ultimately, has significant resources in-house for creating and developing exploits for vulnerabilities in devices and other software in a way that we don't really know a lot about publicly. So when they were forced to announce, with red face, that actually we were able to break into the shooter's phones ourselves, just like we did for the 2016 shooter's iPhone, it continues to sort of prove the point, I think, that maybe the sorts of backdoor legislation that they're asking for devices is not as necessary as they say that it would be. And in addition, because of the engineering changes that have been made to iOS in the intervening time since 2016, it's not even clear whether, had they gone to court over the Pensacola phone, whether an order of the type that was issued in the San Bernardino case would even be technically possible today, given the re-engineering changes in the meantime. So that is that's US devices. As a side note, as we learned from the Rob Ford crack smoking case, because of course that's how we figured this out, Canada has demanded device decryption too, under a provision of the Canadian Criminal Code that I have up here on the screen, that is analogous to the US All Writs Act, that allows a judge or justice who authorizes a wiretap or issues a warrant to order somebody to provide assistance if their assistance may reasonably be considered to be required to give effect to the authorization or warrant. So here's a screenshot from the court order that was issued to Apple on behalf of the Toronto Police for Rob Ford's buddy, Alexander Lisi. And ultimately, this came to light because, bless their hearts, the Toronto Star had filed a request for the court to unseal the documents. Originally, as is standard in criminal investigations, this had been locked as well. I don't actually know, based on just reviewing these documents that the Star had obtained, whether Apple actually unlocked that phone in response to this assistance order or not. Maybe those documents are out there, but I don't actually know how this happened. And of course, Apple has re-engineered their phones to be unable to extract data ever since iOS 8 and onwards. So I don't actually know what the resolution was of this particular case. The good news is last year, the Ontario Court of Justice ruled that this section of the Canadian Criminal Code does not permit forcing somebody like you or me to decrypt our phone with a password, because the Canadian Charter, Section 7, which says everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Section 7 would be contravened by such an order because it would be inconsistent with those principles of fundamental justice. And as far as I can tell in this Shergill case, it doesn't seem like the government appealed to the Ontario Court of Appeal. This is similar to case law in the United States with regard to compelling people to unlock their phones. Under our Fifth Amendment to the Constitution, which gives us the right against self-incrimination, courts have typically said that it violates that right to compel somebody to decrypt and unlock their phone using a passcode. However, they have not come out that way when it comes to biometrics like your face or your finger to unlock your phone. And I don't know whether any Canadian court has considered the biometric unlock situation. So that's a side note about device decryption in Canada. All right, so that's devices. What about the law around encrypted messaging? So as said, chat apps are information services under CALEA. They don't need to follow CALEA like telecommunications carriers do. And from the Apple versus FBI case that happened in San Bernardino, what seems to have happened, because the Department of Justice chose to file that case publicly in the open, the shooter was dead, nothing else, he wasn't going to be able to hide any evidence then. So they chose to file that publicly instead of filing it under seal, as so many of these criminal surveillance type cases get filed. And I think maybe the government was expecting public opinion to side with them, but instead public opinion really sided largely with Apple. And so DOJ's lesson learned was, okay, if we're going to file these requests to try and compel decryption from a provider, we should do it in secret. And so we found out, due to leaks to the press in the summer of 2018, that Facebook had allegedly been demanded to somehow change the encryption on their Facebook Messenger chat and voice calling app in order to allow the wiretapping of voice calls. This is something that is a feature that Messenger has to allow end-to-end encryption. It's not turned on by default, which can make all the difference in the world, just depending on whether people fiddle with their settings, which we know from research that most people don't. But the government had allegedly tried to force Facebook to make these changes because there was this sprawling investigation involving gang activity in Central California. And allegedly they lost an attempt to try and compel Facebook to do this, but we don't know why. We don't even have we don't even know what the case number, the case title was. And I was part of a group that brought and lost a lawsuit to try and unseal at least the court's opinion and what's called the docket of the case, that would at least show, like, when was this filed? What's the case number? What sorts of documents were filed in the case, even if those documents are sealed? Normally, judicial opinions are public because the public needs to know what the law is. People need to know what duties they have. The police need to know what authorizations they have. Other judges need to be able to know what other courts have said about the law and how they have applied it. We don't know any of that. We're not going to know any of that, despite my best efforts to find out. So we don't know what the government's legal argument was. Did they invoke the All Writs Act? Were they using the federal statute that permits wiretapping of voice calls? What was the court's reasoning in denying the government's request and siding with Facebook? We don't know. We can infer that Facebook won because I had mentioned earlier that Facebook had these plans to upgrade to end-to-end encryption across all of their messaging services. They announced that in early 2019, and this case allegedly happened in 2018. And so we can infer that if they had lost, they probably would not have made that announcement, and they're free to push forward with this plan. But that seems to have been a main reason, this announcement by Facebook, that the debate in the United States swung from focusing largely on devices to focusing much more on chat. So overall, as I said at the top of the hour, strong encryption for devices and end-to-end messaging is, as far as we can tell from these cases under current US law, it is legal, and the providers of those things cannot be forced to change their encryption to allow access to law enforcement for devices or communications. And companies like Facebook and Apple, as well as much smaller entities like Open Whisper Systems, which makes Signal, or Wire or Wicker, or pick your favorite, can and do act in reliance on this apparent state of the law. And if you are Facebook or Apple, you have the deep pockets to test that and to fight it in court at the appropriate time. So there isn't currently any applicable law that requires weak encryption, but our Congress this year has been working on changing that for the worse. You may have heard of the Earn It Act bill, which stands for the Eliminating Abusive and Rampant Neglect of Interactive Technologies. The passion for back deriving from short titles that they want to use is one of the lesser sins of our Congress, but this doesn't even make sense. I don't think it's even grammatical. So even the title is bad, and almost everything about it is bad. This bill has now been introduced in both houses of the Congress that would curtail an important legal immunity that providers enjoy when it comes to child sexual exploitation material on their services. So it includes not just imagery, the previous phrasing for that being child pornography, but now the shift has moved to, and this bill would in fact change all instances of child pornography throughout US federal law to instead be child sexual abuse material, or CSAM. This bill would not just include CSAM, it would also cover other related exploitation offenses such as grooming, enticement, sex trafficking, etc. And it would abrogate this legal immunity under a law called Section 230 only for online child sexual abuse material, child sexual exploitation rather, not in general. So what's Section 230? Section 230 is an important, another important creature of the 1990s, passed in 1996. It's the federal law that says that online platforms, websites, social media, chat, email, etc., cannot be held liable for what their users say and do on the service, with certain exceptions for federal criminal law and for intellectual property law. So as an example, if I defame you on Twitter, you can sue me, but you can't sue Twitter. If I commit a state law crime on Twitter, say I violate a US state's criminal law against cyberbullying, then same thing, state prosecutors can charge me, but they cannot criminally charge Twitter. What this bill would do would be to abrogate that immunity, meaning that because 230 covers civil lawsuits as well as state criminal charges, providers would no longer enjoy Section 230 immunity when it comes to civil lawsuits against providers brought under federal child sex abuse material laws. And it would also abrogate their immunity for civil claims or criminal charges under the state equivalent, because all of the states, of course, also have their own laws with respect to CSAM. So this Section 230 immunity that has been around since 1996 was, like the carve out for information services in CALEA, hugely important to allowing the US technology sector and the internet sector to flourish and indeed to make the internet what it looks like today. And it's a major reason why so much speech, both good and bad, has flourished online, because providers largely don't have to fear liability for their users' actions. And this bill would change that. It builds upon the passage in 2018 of a law called FOSTA, the Fight Online Sex Trafficking Act, which was the first and so far the only law to amend Section 230 to carve out an exception to that immunity. And it got rid of providers' immunity for online sex trafficking on their services. That law has both harmed online speech. Immediately, Craigslist shut down their entire section for like massage therapy, just in case there might be some trafficked, people ads in amongst there. And it imperiled the livelihood and even the personal safety of sex workers. There have been research showing the negative impact on the personal safety and the ability to make a living of people who do sex work, for whom it is much more safe to be able to vet clients and share information with each other online than to be out on the street without the ability to know anything about the person whom they're meeting. And in fact, FOSTA, because of this, the consequence for legal speech, for massage therapy ads, for websites that want to provide sex education materials for teenagers, for example. One of my colleagues at Stanford is one of the lawyers who has brought a constitutional challenge to the FOSTA statute for being unconstitutional and for violating our due process and free speech rights due to its effect on sites that host protected, entirely legal speech that does not run afoul of sex trafficking laws. So similarly, the abrogation of Section 230 immunity contemplated by the Earn It Act would do for child sex abuse and child sexual exploitation crimes online what FOSTA had done for sex trafficking. And in fact, there's even some overlap there. This would be problematic if it looked anything like what we've seen with FOSTA so far. FOSTA hasn't even actually been invoked in that many lawsuits. So it seems like it has had this extremely detrimental impact on legal online speech and led to a lot of websites shutting down portions of their services out of fear of liability without very much actual upside or any benefit at all to offset the detriment, which is, even potentially a matter of life or death for people who engage in sex work. So far, the Earn It bill has not passed out of either House of Congress. It passed out of the Senate committee in which it had been introduced over the summer, and the companion bill that is largely identical was introduced last month in the House of Representatives. But we have very little time left in this Congress. We have a lot of other things to do. The next Congress will commence in early January, and it seems to me like this bill will likely be reintroduced and may be a big problem in the next Congress, in no small part because this is not just a bill brought by some fringe group. It is bipartisan and has a number of sponsors from both of the political parties. And so it is going to be kind of problematic, I think, in the next Congress, especially if we see sort of this continued, what's been called the techlash or the tech backlash against major companies, and the idea that you just have to do something about big tech. And this is the particular cudgel that that Congress has picked. So as I said, like FOSTA, Earn It doesn't take away 230 immunity entirely. It only takes it away for a particular kind of offense. That was sex trafficking under FOSTA, and it's child sexual exploitation material under Earn It. The bill has changed over time. Now, in its current version, it completely cuts off 230 immunity. Do not pass go, do not collect $200 when it comes to online child sexual exploitation material. The original bill explained why this bill is called Earn It, because it provided a couple of safe harbors by which entities could earn continued immunity instead of losing it. They would have been guaranteed immunity if they had certified compliance with a set of best practices for preventing online child sexual exploitation that would be developed by a commission headed by the Attorney General and approved by Congress. Alternatively, they would have the potential to implement their own reasonable measures that they selected for preventing this kind of material on their service, although that would not have guaranteed immunity. Those safe harbors are not in the revised bill. There's nothing left to earn, so the title doesn't even make any sense anymore. That immunity under Section 230 is gone no matter what. In addition to being inspired by, it seems to have been inspired by Facebook mostly, both by that announcement about their messaging services and by a New York Times story that came out a year ago about the volume of child sex abuse material on Facebook. So it seems like this bill at first glance might seem targeted at Facebook, targeted at social media platforms, which is the context where a lot of the discussion around Section 230 focuses in the United States. But Section 230 isn't just about social media. It has a definition of interactive computer services, again, interactive computer services, information services under CALEA. They both cover a very broad spectrum. So interactive computer services can cover websites, apps, email, social media, messaging, chat, the cloud, etc. So it's mostly going to be targeted in this sort of neat little sort of bait and switch, I think, is much of the popular anger at platforms is about the stuff that you see in public. That's terrible content, that is hateful, that is racist, that is abusive, that is harassing. But that's the stuff that is not end-to-end encrypted. It's the stuff that is perfectly out there for everybody to see and get angry about. However, the neat bait and switch would be to try and impose liability with respect to the context of mostly child sex abuse material trading or enticement or grooming, which is mostly going to happen in private communications channels, small group or one-to-one, rather than out there in public for all to see. Of course, that material still does exist in non-encrypted channels and gets taken down. But the neat little trick that is being pulled here is to take popular anger at Section 230 as a law that has been considered to have gone too far by allowing all this shitty content to flourish online in the public eye, and turn that into a bill that would primarily target a context of private one-on-one or small group private messaging, which is where the concern is that encrypting end-to-end more communications, as Facebook plans to do, would make it harder to detect when this kind of illegal content is going on. So you'll remember also that these are the information services that CALEA leaves free to design their encryption however they want. So, you know, this is a different approach. This is sort of going backwards by the introduction of this bill on that compromise that had struck in the 1990s with CALEA. Previously, the FBI and DOJ had tried to lean on providers to voluntarily redesign their services, or they tried to use these ill-fitting laws like the All Writs Act that were already in existence to try and force providers to decrypt or to change their encryption. But this instead is a different approach, and it comes at it kind of sideways by taking something that, of course, everybody thinks is bad and that no senator wants to be seen voting against, and trying to turn the clock backwards on the compromise around encryption that had been struck in the 90s in CALEA. Because of the revisions to the Internet Act bill over time, because of this curtailment of Section 230 immunity, rather than directly imposing consequences on providers for offering end-to-end encryption or for having this material on their services, this would expose interactive computer services to liability under potentially 50 or more state-level laws, the states, DC, various US territories that relate to child sexual exploitation material. And, you know, the newsflash here is that there is already federal criminal law that tells providers that they have to report child sex abuse material on their services when they learn about it, when they have actual knowledge of it. And as said, Section 230 does not, has a carve out for federal criminal law. So as is, nothing is barring the Department of Justice from prosecuting Facebook or Twitter or whoever for having this kind of material on their service in violation of, and not reporting it, in violation of existing federal criminal law that requires reporting. However, that actual knowledge standard in the federal law is relatively high. It does not require and can't require proactive monitoring or scanning for content, even though many major providers do that anyway on a voluntary basis. Whereas under state law, the standard for liability for having such material on one's service can vary. It may be much lower than that actual knowledge standard. It may be a negligence standard or a recklessness standard, depending on which state you're talking about. And so this bill would both remove immunity from liability for state criminal charges and for civil lawsuits against providers, while simultaneously lowering the standard for liability by substituting this variable, state level standard for the federal actual knowledge standard. And because the DOJ is already free to enforce the federal criminal law that imposes duties on providers, it's not really clear to me that this bill is necessary at all, given that providers have to and already do report millions of times a year the material that they find on their service. That was what was in that New York Times story from a year ago, was these shocking statistics about the millions of reports a year, which suggests that they are in fact finding this material. And the concern being, if you encrypt more of it, you're going to have to turn to other tools that don't allow you to see the content. It will be more difficult to be able to detect that material, and your voluntary existing scanning efforts will not work as well. But if there were a mass epidemic of non-compliance among providers with their existing duties, nothing would stop the DOJ from prosecuting them, and you would expect to see front page news about such prosecutions for having actual knowledge and not reporting, and there haven't been any. So they're doing everything that they're supposed to do under federal law, and yet this bill is like, well, you should be doing something else and something more. The Internet Act would also establish a commission, as I mentioned. That part is still in the revised bill. It now is totally advisory, though. It used to be that the commission's best practices for preventing and addressing child sex exploitation material on one's service would have been passed into law by Congress and therefore would have been mandatory. That posed all kinds of problems, legal problems, and so it was taken out of the revised version of the bill. Now the commission, if this bill were to be passed, would still be charged with coming up with best practices, but it would be pretty much just out there as like, well, you can do this if you want to, but there would be no legal binding force to any of them. And the way that the commission would be composed is largely stacked towards being mostly federal law enforcement friendly. And while they have thrown a bone to security folks and civil liberties folks by requiring that there be a couple of experts in consumer protection, civil liberties, civil rights, or privacy, and 2 experts in CS or software engineering in crypto, data security, or artificial intelligence, that doesn't necessarily mean anything. You could, that or means that you could pick 2 experts in consumer protection who are experts on child safety seatbelt laws and car seats or organic labeling for foods. They don't necessarily have to have any expertise. You could pick people who don't know anything about privacy at all. And the CS experts could be people who are experts in AI while also being fervently anti end-to-end encryption, as one of the leading experts in AI who came up with the photo DNA system that is used for proactive scanning for child sex abuse content online by many major providers. In fact, that's Henny Farid, who is now at UC Berkeley after previously being at Dartmouth. And so one of the questions of these revisions is, well, what's the point? If the commission has these best practices and they have to, come together and submit them to the Attorney General, and the Attorney General puts them out there, what is the point of them? And the only explanation I've heard for this, for why you'd still have this, would be that it potentially could influence the states to pass new laws at state level that could pertain to and codify the best practices that would be recommended by the commission. So it could be a way of allowing liability sort of indirectly, again, by opening up charges or civil lawsuits under state law for more state laws to be passed. There are a lot of legal problems with CALEA. There's this tension that I mentioned with the information services carve out. The bill doesn't mention CALEA at all. Allowing liability for doing exactly what CALEA plainly allows them to do, for providers to do, seems to me like a problematic result. The First Amendment right to free speech, like FOSTA before it, this bill would scare providers into censoring lawful speech by opening the door to liability. So it incentivizes censorship by platforms. And of course, the things that allow people to trade this heinous content and entice and groom children online are the basic functions of every online service: communicating between one user and another, transmitting a file from one user to another, sending files to yourself, storing files remotely in the cloud. All of those is just what the internet does. And so it seems like a terrible policy idea to say, well, when that gets used for child sexual exploitation material, it's going to be deemed, potentially deemed reckless by a court to have those basic functions of letting users talk to each other and upload files. There are also some weird throwbacks to 90s era sort of prudish online internet censorship bills that were concerned with kids looking at porn online, like having the commission make recommendations for best practices regarding age gating and parental control. Those are measures regarding access to legal pornography. They don't have to do with illegal child pornography. What are they doing in this bill? There's also a problem under the Fourth Amendment, which governs searches and seizures and requires a warrant. Otherwise, the search is deemed unreasonable in most circumstances. And the consequence of an illegal search in violation of the Fourth Amendment is that evidence obtained by that illegal search will be excluded from the subsequent court proceedings. This is the very tense tightrope walk that providers have been doing by implementing photo DNA or other services for voluntarily scanning for child sex abuse content on their services. As long as they do it voluntarily, it is not a constitutional problem. If they were to be mandated by the government, it turns into a mass warrantless search and turns those providers into arms of the government, in which case those mass warrantless scans by an arm of the government who's been mandated by law to conduct these scans, that would result in evidence being suppressed in all of these cases, and all of these accused worst of the worst defendants would walk free. So if the Earn It bill were to end up mandating proactive monitoring or scanning, it could backfire at its central goal. In an earlier iteration, it very clearly did basically mandate monitoring or scanning. It has been revised to try and address that, but it still opens the door to, as said, 50+ state laws, if any of those require monitoring or scanning, or otherwise basically leave no other option to avoid liability other than to do that, then there would be a big danger, I think, of mass suppression of evidence found by those, as currently now, voluntary searches on many major online services that would completely go against the entire point of having this bill. And it's just, even though Congress tried to fix this after I and other advocates for privacy pointed out this state actor problem under the Fourth Amendment, it's still sort of abominable to me that Congress is willing to roll the dice and is willing to potentially pull away this fig leaf because it entirely relies upon the voluntariness of those searches, and courts having so far said, yes, those searches are voluntary. They are not being compelled even by the existing reporting law. That's why that's an actual knowledge standard that you have to find out about it. You can't be compelled to go and look for it. Otherwise, you have this big Fourth Amendment problem. The consequences for encryption would be, as said, maybe a state court would find that end-to-end encryption is a reckless or negligent thing to do because then the provider would not be able to see child sex abuse material. This bill is not in its face about encryption. The only mention of it anywhere in the bill is in the qualifications for 2 CS experts on the commission, but this is the elephant in the room. It's easy to foresee that those non-binding best practices would condemn any encryption designs that don't have an access mechanism for law enforcement built into them. And there's very weak protections in an amendment to the bill that came out in late June, early July to try and protect encryption, but it doesn't really go far enough because it's just going to lead to litigation over whether a lawsuit is brought because of encryption against a provider, in which case this amendment would require the suit be dismissed, or for some other reason. And if you are a civil plaintiff or a prosecutor under a state court, you're just going to find some other pretext for suing a provider that is not because of the encryption. And it also doesn't address other recent proposals for giving access to law enforcement, such as client-side scanning, or the UK GCHQ's ghost user proposal for silently adding a government surveillance watcher to an otherwise end-to-end encrypted conversation between two people and suppressing notifications to the users that you have this third person listening in. And then the House version of this bill has even weaker language in it. So if passed, this bill might incentivize providers to change their encryption design rather than go to the trouble of fighting out lawsuits and criminal charges all over the country. And so it's a clever way to try and punish providers for strong encryption without directly banning it or amending CALEA. I'm running short on time, but I need to talk to you about a much more dangerous bill called the Lawful Access to Encrypted Data Act, which would render that amendment for encryption in the Internet Act a total nullity. This is like an actual honest-to-God backdoor bill. It would require a mandatory built-in backdoor for practically every device or service that Americans use that has a computer in it, touches the internet at any point. And this would be the end of strong encryption for stored data on devices. Those would be illegal to sell in the United States, and there would be an outright ban on offering end-to-end encryption in the United States. So all of our devices and services would be forced to be insecure by design. And of course, that will have ramifications beyond US borders as well. This bill would require larger providers, meaning those that have over 1 million users per month, or that have sold more than 1 million devices in any given year since 2016, to proactively design in a decryption capability and to be able to hand it over in legible form. If you do not have such a capability, or if you are a smaller provider, the Attorney General can still serve an assistance capability directive on you, commanding you to build or maintain a decryption ability. Those directives seem very clearly to have been inspired by similar mechanisms, technical assistance notices that were codified in the UK law in 2016 and Australia law in 2018. So, inspiration coming from other countries on that. The capability that providers would be mandated to add would then be up for use whenever the government went to get search warrants, a seizure warrant, a wiretap order, an order for metadata. As said, right now, those laws do not clearly require technical assistance in the form of decrypting information. And in fact, CALEA says that you don't have to. This would implicitly close the information services carve out in CALEA. It would expressly carve the encryption carve out for telcos covered by CALEA. And it would amend the surveillance statutes both as to foreign intelligence surveillance and to domestic law enforcement to clarify explicitly that decryption is one of the types of technical assistance that can be required when it comes to carrying out a warrant or a wiretap or metadata court order. And this is pretty scary, obviously. It's not clear how far down that goes. It's not clear to me whether one of these directives could be served on like an individual GitHub repo maintainer or a kernel dev for the Linux kernel. Could you just serve it on any individual employee at a particular company? How would it even get through, given all of the, the obstacles in the way to having one person push to prod? And this bill is extreme. It's a full frontal nuclear assault on encryption in the United States. It was introduced by the same guy who co-authored the EarnIt Act. It's him and two other Republican senators who introduced this, evidently as a way to make EarnIt look like the lesser evil. And the whole point is that like the lesser of two evils is still evil. It doesn't just make EarnIt more palatable. It hasn't gone anywhere. It wasn't intended to go anywhere, but it still shifts the Overton window for the encryption debate in the United States. Because as said, there have been multiple efforts to renege on the compromise struck in the 1990s by law enforcement, but it's never gotten to the point of an actual piece of legislation that is this hostile, this aggressive, being actually introduced with an actual bill number in Congress at any point in the last 20 or 25 years. And so by shifting the Overton window on this, even if it's not supposed to get past this session, now that they've crossed this line in the sand and opened this new hostile front against encryption, both as to data at rest and data in motion, there's nothing stopping this bill or one like it from being introduced in the new Congress next year. And with Congress howling for the blood of big tech recently as a bipartisan trend, not just limited to one or the other party, it's not going to magically stop next week, even if we come to our senses when we have election day and vote out our current president, who, by the way, multiple Canadians told me was going to be no worse than Stephen Harper, which has turned out not to be true. So, this is terrifying to me, and I don't necessarily know what's going to happen in the next Congress. Our Attorney General is zealously anti-encryption. He used to be the AG under the first President Bush in the early 90s, during which time he oversaw an illegal mass spying program on Americans' phone calls. And of course, American society is dependent on encryption. Even the former General Counsel of the Federal Bureau of Investigation, who was the GC at the time of the San Bernardino fight, says encryption is too important. Embrace reality, deal with it. And of course, during COVID, this is like the worst possible time to work and to weaken cybersecurity. Everything that we're doing now is online. We really do not need Zoom abandoning its plans to provide easy end-to-end encryption for all these video calls. I don't know whether there will be a silver lining in the form of public understanding of the stakes better, and it'll be harder to just say encryption is just something that criminals use, but I don't know yet what the future holds. And then the question I think I'll leave you with is whether Canada might be next. There's something called the Five Eyes Surveillance Alliance for sharing intelligence information among the USA, Canada, UK, Australia, and New Zealand. And as I mentioned, the UK and Australia have bills that pertain to encryption and surveillance that seem to have inspired the bill in the USA. New Zealand has something kind of similar to the US CALEA bill from 2013. So as you can see, these dominoes tipping, the question is whether Canada will then feel that its hand has been forced into doing something similar. There have been multiple joint statements by the Five Eyes countries urging companies to weaken their encryption or else we'll come and do it for you, including most recently early this month. And that is at odds with the position that Canada has been taking for the last 20 years, including as recently as 2017, where Canada has committed to having no intention to undermining the security of the internet by impeding the use of encryption. And yet it's been joining these Five Eyes statements. So you have to sort of question whether you might be next. If you want to find out more about Canada's specific encryption policy, the best resources for that, I think, are the Citizen Lab at the University of Toronto, and the University of Ottawa's Faculty of Law has CIPIC, the Canadian Internet Policy and Public Interest Clinic. That's all for me. I know I've been running crazily over time, but I want to make sure that we have a little bit of time for questions. We have a first question in here, focusing on law enforcement, but what about other agencies that have a purview over encryption, such as the National Institute for Standards and Technology, et cetera? What are those agencies saying or doing, and what do their voices carry weight in policy setting? Yes, so the national intelligence, the intelligence community and several former high-ranking officials from various three-letter agencies have come out and urged and said, like, undermining encryption is a stupid idea and you need not to do it. NIST, I think, tries to stay kind of detached and above the fray. They obviously are looking for ways of making encryption better and stronger. They have not been announcing any competitions for weaker encryption so far. And so having the intelligence community be on one shoulder and law enforcement on another shoulder for policymakers has been, hopefully a modulating effect, where of course intelligence has capabilities and access and toys basically that law enforcement does not have. And so I think, part of the reason that we haven't had an absolutely ruinous bill be passed so far might partly be because of members of the intelligence community, either publicly once they've left their jobs in government, or privately while they're still there, tapping Congress people on the shoulder and the president saying, please don't weaken encryption, like we cannot afford that. So that's my answer to that question. Do we have further questions? I want to make sure that we'll have some time after this for me to meet with students in a separate Zoom meeting. And I know I've run over time.
If there are any quick questions, just put them in the chat or raise your hand in the hand raising mechanism. If not, as Riana said, we are over time. So if there are no other questions, let's just thank Riana for her talk.
Thank you. Sorry I went over, Ian.
No worries. Okay, thank you. Thank you all for coming. And please keep an eye out for future talks in the CrySP speaker series on privacy. Thank you all.
All right. Thank you.